So, Chapter 3, ADJ 211, for criminal law, evidence, and procedure. We are talking about the elements of criminal liability in Chapter 3. We've been building on our core concepts in our book here of basic understanding of the law and the foundations of law, legal foundation. We started talking about limitations on law in Chapter 2, and federalism. So now we need to start, now that we have an understanding of the basic limitations, we need to start talking about liability. And liability is a very interesting concept. We're going to talk about crime and criminal liability specifically. So if you open up your book here in your Moore and Worrell book, Criminal Law and Procedure, to page 68 and start following along, we're going to go through some of the main terms in the chapter. So we're going to talk about mens rea, we're going to talk about actus reus, we're going to talk about strict liability, the general parts of the law, the specific parts and special parts of the law, harm, crime, causation, concurrence, ignorance of the law, mistake of the law, and the difference between legal and factual cause. So let's start on page 68 here and explain the difference between conduct and a result. So conduct and result. What do we mean by that? So a conduct crime, crime with no requirement for a resulting harm. While result crime is crime that actually requires actual harm. So when we are thinking about a conduct crime, what is a conduct crime that comes to mind that doesn't have to harm someone? It's just if you do it, it's a criminal offense. So think about that. What is one that you can come up with in your head? Right? If you look at the book, sometimes reckless driving, some sort of law where it could hurt someone, but the conduct itself did not harm someone, could be a conduct crime. Well, a result crime is something that actually requires harm, a death, an injury, something like, assault and battery requires harm. So there's conduct crimes and there's result crimes, or injury. You could almost even call it injury crimes, harm crimes. If the larceny was from a person and it resulted in harm and economic harm, that could be almost considered some sort of injury or harm. So the resulting harm, when we talk about that, we're talking about the essential element for a result crime, is that there was some sort of harm associated with it. When we're talking about law in itself, when we're talking about the general part of the law, we need to focus on the principles that apply to more than one crime. It's the general part of the law. It's all law for the most part, and the general applicability of the law. Well, when we talk about the special or the specific part of the law, when you contrast that, we're talking about law that defines specific crimes, right? So you have the law in terms of the overarching law, and then you have the special part of the law, the specific part of the law that defines criminal behavior. Flipping over to page 70 and going forward to 3.2, we'll start talking about the elements of result crimes, the elements of a crime, right? Actus reus, what's the key word there that we're talking about? I know we're talking about Latin here, and you're seeing things that are starting to turn up, that are words that you're not used to seeing, but actus reus, when we're talking about the act in itself, actus reus meaning the evil act, reus meaning the brain, the mind, the evilness of the act itself. It is a core requirement of the crime is that there was an act, an evil act committed, a bad act, right? Some sort of requirement that the act, was in itself, a bad act. While mens rea is the mind, the evil mind, the evil intent. So we talk about actus reus, we talk about mens rea. You'll start hearing these come together because not only do you have to have the intent or the mind that goes along with the crime, but you have to have the act that goes with the crime. They have to concur. They have to have concurrence together. When we talk about mens rea, we're talking about the guilty mind, the mental state of the criminal, of the criminal intent of the actual defendant. And then the concurrence of both of those happening together, simultaneously, causing, simultaneously that the act happened at the same time as the bad intent. Temporal and motivational concurrence, as you'll see it referred to. There are liability crimes that are strict, that do not require there to be a mental act or an evil act, or excuse me, an evil mind. It just means that the act was committed. There doesn't have to be an intent or an evil mind behind it. It just means that the act in itself, DUI in itself, the act itself is illegal, right? Whether there was an intent for it or not, right? We talk about causation. Causation being the requirement that the defendant is responsible for the harm in the crimes, in the result crimes. You have, but for the act that was committed, there was no cause of harm. Whether it's factual causation or legal causation, a direct cause or an intervening cause, all terms that we need to be familiar with. Which leads us to harm. So if you have the act, the mind, they happen together, they cause something, they caused harm. And what do we mean when we talk about the word harm? Harm in itself, something that hurts, right? Something that causes a disruption, a pain, an injury, death, financial cause, some sort of economic or social cause. Harm in and itself. Something happened, whether out of negligence, recklessness, malice, aforethought, whether the motive was there or not for the mens rea, something happened in itself that caused a harm to a victim or to an entity, to a business, to society. Something caused some sort of harm. So going forward, let's talk about actus reus. Let's go back and we'll put all these things together. What you have in front of you is a Venn diagram of sorts. And in order for there to be a crime, especially in Western society and U.S., Western law, all these things have to concur together. And as you can see there in the middle, between the act, the mind, and them happening together at the same time is how we have our resulting crime. It's a part of a triangle, part of the Venn diagram, that when these two or three things, in this case three things, come together, we have a resulting crime. Actus reus in itself, meaning the evil act or the criminal act. Whether the act was by commission, a direct action, or whether it was by omission in a failure to act when there was a duty. If you have upheld an oath, like a police officer, you uphold an oath to protect and serve, and you fail to act where you were supposed to act. A doctor failed to act where they were supposed to act. There is a harmful act and possibly a harmful mind that goes behind that. So do you have a crime? While a bystander who might have no connection to an individual, do they have a failure to act if they don't act in your terms? Is there an oath or a commission or something that was legally represented in order for them to act? So actus reus, it has to be voluntary, right? The act itself, it has to be done with volition from the person, from the individual. It can't be forced, it can't be coerced. We're going to talk about all those things, entrapment and all that stuff as we go forward. But as you see in the picture, the involuntary guy is slumped over the wheel. It could be, there's keys in the ignition, it could be a drunk driver, right? However, if he just went to the doctor and had a surgery or had something done and was given a medicine involuntarily, so you were given nitrous oxide, pain medication, or something like that, and then you were under the care and the guise and the auspice of that professional who's caring for you, and they fail or neglect with negligence to care for you and allow you to then go and drive a car while you're supposed to be under their care, and you get in a DUI crash, driving under the influence of a drug or a narcotic. In this case, you're under pain medication because you just had surgery on your foot or something, and you crash your car. Was the intoxication of the individual voluntary or involuntary? Voluntary meaning they went in it purposely and they drank alcohol or they took drugs and then they got behind the wheel of the car. Or while they were supposed to be under the care of someone else, they were involuntarily intoxicated and then drove a car. The act itself would show that the car driving was voluntary. However, the intoxication was not voluntary. Same being said, if somebody slipped something in your drink or someone drugged you, that is not a voluntary action connected to that crime. So, when the failure to act can satisfy actus reus, what we saw in that example a minute ago, it was the relationship, the contract, the duty, the assumption of care, or some sort of statutory requirement that causes someone to have to act. An oath, a parent, some sort of relationship or binding contract, a legal contract, a landlord, a landowner, something that was known to be perilous, that someone else, dangerous dog, and you're not confining your dangerous dog or something like that, and you fail to act when it attacks or something like that, you could be liable for failing to act. So that's where the actus reus and a failure to act can satisfy actus reus. But for the most part, the act itself is a commission as opposed to an omission. So going forward, 3.3, we're talking as we go through, saw the connection of the five, of actus reus, mens reus, causation, and harm, with the concurrence. So 3.3, we're talking about mens rea and concurrence. So we talked about the act, whether the commission or the omission of the act. Now let's talk about the mind. So actus reus being guilty act, mens rea meaning guilty mind, the criminal intent, the mindfulness behind the act, the intent, or they should have known intent, right? So when you see mens rea, you're thinking men's mind, I think of men's person, brain, mens rea. So the intent, it's an intent description. General intent, specific intent. Again, we're looking here in the book, pages 79, 78, and 79. Direct intent, transferred intent, oblique intent, general intent, specific intent. What you have in front of you, general intent and specific intent, two of the most common ones. General intent, you generally intended to commit the act of the crime only. The intent to commit the actus reus of the crime only, generally. Specific, however, being the intent to commit the act to achieve a specific criminal result. So you could just intend to cause the act, but not the result. Or you can specifically choose to commit the act and achieve the result of the act. Those are part of the intents. You'll also see, again, transferred intent and oblique intent, page 79, talking about consequences of a person's actions that are not desired, but you should have known better. Driving under the influence. You weren't desiring to cause involuntary manslaughter, vehicular manslaughter, but you should have known that driving a car dangerously under the influence could reasonably be foreseen to cause that. You shouldn't shoot, think about Chesterfield a few years ago, you shouldn't shoot a gun straight up in the air in celebratory, 4th of July fashion like you see on 4th of July and New Year's and a lot of locations. You shouldn't shoot a gun up in the air because that bullet is going to come down and it's going to strike something. It's still a projectile. What goes up must come down. So reasonably, it should have been foreseen that if you shoot that gun, even though you might not have been intending to kill someone, there was a reason to believe that the intent would cause harm. Or transferred intent being the defendant's intent to harm one person is actually transferred to another victim other than the actual, right? So, person A wants to punch person B in the face. Person B ducks, and when they duck or they move, person A punches another person C in the face. They weren't intending to harm and injure person C. However, their intent was transferred because B moved and they were intending to hit B. They ended up hitting C, right? That it was transferred because of the action itself, and the intentful action just transferred to someone else, right? So with mens rea, we have to talk about the four levels of mens rea, the four ideas behind the guilty mind, the evil mind, the bad mind, the criminal mind. When we talk about mens rea, we have to talk about purpose, knowledge, recklessness, and negligence. Is one, then we'll break it apart just like a pie here. Purposeful, purpose, mens rea. If you are purposefully committing an evil act, purposeful, I mean, it is what it is. It is meant to cause the harm in which the act is intending, right? When we talk about purpose, we talk about the actual understood reason why the act would be committed. A shoplifted, this item from this store, and their intent was purposeful to take that item without paying for it from that store, commit larceny, right? Knowledge of a guilty act. When we talk about knowledge, it's an interesting thing, whether we're talking about motive or we're talking about, should have known, not to commit a crime. To knowingly commit a crime is not the same as intentionally committing one. In some cases, rather than intending to commit the harm, the defendant may only be required to know that the result is virtually certain. So some statutes and locations, Virginia specifically, they have added or have required the word knowing or knowingly to a statute. So you could have intent without knowledge, but knowledge is the key. So knowingly operate a motor vehicle while under the influence of a drug or a narcotic or alcohol, right? Deliberately, willfully, do something, so that the crime is even more specific, that you not only intended, but you knowingly did it, right? You knowingly injected a drug into your arm. You knowingly shoplifted. You knowingly, assaulted and battered somebody. When we talk about recklessness, we're talking about the defendant's intent that they create a risk. They're by their evil mind. They create a risk, and they choose to act in disregard of that risk. The risk is known. It's so purposely reckless, right? When we think about reckless, you automatically probably put reckless driving in your head. And categories for reckless driving in Virginia, when we're talking about like 46-2, 862, and 852 with speeding and general reckless and the Virginia state law, we're talking about either actions that take a vehicle out of control and knowingly could cause harm or injury or damage to property or person, speeding 20 miles over this posted speed limit or in an unsafe road condition, or anything above 80 miles an hour in the state of Virginia is considered reckless, because knowing the weight and the velocity of a vehicle, the damage a vehicle, essentially a missile can do, a 2,000, 3,000 pound vehicle going 80 miles an hour, and the distance it takes to stop it. If you're interested in it, look it up. It's a long distance. It's a football field to stop a vehicle at 80 miles an hour, a standard size vehicle at 80 miles an hour. So when one engages in conduct or recklessness to the point where they should have known, they have purposeful and reckless, mens rea. And then the fourth component, negligence. The intent, behind the crime might be unconsciously creating a risk. It does not act like a reasonable person would do in certain circumstances. When we think about negligence, we think about like child neglect, a mother, father, parental structure, parental unit is required to care for a child. They have a duty to them. They have an obligation. They have a structure where they are supposed to provide care. So when they don't, there's negligence. It would be reasonable to believe that you have to feed and clothe and send your child to school, or at least educate them in the state of Virginia. So not doing it is just as much, going back to the omission, not doing it is purposeful negligence, or should have known that not doing it would do that, right? If there's a lot of discussions behind, negligence when it comes to health care and some people's opinions on how to medicate or vaccinate their child. But, short of religious exceptions, not taking your child to the doctor when they have a broken neck or something like that is neglectful. Therefore, in turn, creates the negligent mind, right? The guilty mind, the bad or evil content mind. So, intent, purpose, right? Conscious object to engage in conduct or cause or harm. Knowledge, practically certain that the conduct will cause a specific result, right? Recklessness, conscious risk, negligence, and unconscious risk, or should have known risk, right? When we talk about motive, modus operandi, when we're looking at page 82 here in the book, motive, the inducement, which is an interesting word, inducement, or reason a defendant chooses to commit a crime. The MO, the modus operandi, the mens rea, likened to mens rea, but distinct and separate, right? When we talk about motive, we're talking about the reason why someone had that mindful, evil mind, the intent behind the evil mind, even. As like it says, it's been defined as an idea, belief, or emotion that impels or incites one to act in accordance with his or her state of mind or emotion. Motive has also been defined as circumstance tending to establish the requisite mind, right, guilty mind, for a criminal act, right? The reason behind the mens rea and the actus reus is the motive. So how does one prove mens rea? Proving mens rea is an essential component of criminal conviction. Quite another for a prosecutor to prove it in court. You have to come up with motive most of the time that leads you to the mens rea. But the guilty mind is really what establishes guilt, guilty intent, right? Knowing, purposeful, knowledge, recklessness. So when we talk about all these things together, we talk about mens rea, actus reus, concurrence, causation, and harm. We then lead into liability. Are you liable for your act in your mind? Are you liable for your behavior and the intent behind your behavior? So when we talk about, again, page 84, 3.3, strict liability. Strict liability is, what it sounds like. One that is liable strictly for their action. Crimes that do not require the guilty mind or the criminal intent behind it. Just the fact that you did the act. You were speeding. The act in itself is a strict liability offense. You don't need a reason why someone was speeding. You don't even need a motive. You don't need an intent. It's just that they were doing it or they weren't doing it, right? They were doing it, therefore it's strict. You were driving under the influence. As long as you can prove that it wasn't an involuntary intoxication, you were doing it. Therefore, the liability is strict. You did it. Here's the crime. That is a strict liability offense. So think about some other strict liability offenses that do not require the guilty mind, right? Do not require the requisite mindful intent behind it. Here you go. Here's your traffic stuff. You're selling alcohol to minors. Statutory rape, right? It could be consensual, sexual intercourse between an adult and a child. And because of the law being strict as to the liability, it is a crime no matter what the circumstance is. So we talk about liability. We have to talk about concurrence together again. So all these things coming together, the mind, the act, the motive, liable or not, harm, all that, concurrence in itself means these things acting simultaneously. Page 85, the actus reus and the mens rea existing simultaneously, both temporal in time and motivational linkage. So there's a temporal concurrence where the act is happening at the exact same time as the mind. Not that one was of, insane mind and did the act. So if someone's deemed to be insane, they weren't of, and we'll get into insanity later on, but they were not deemed to be at the time of guilty mind because their mind was not in the right showing. So therefore the act and the mind did not concur. So someone could be used that defense when we get into the defenses of insanity or motivation. The mens rea must be linked again to the act. So if it's not act, if it was an intentful crime, but you can't show that the intent was linked to the crime, just because you thought it doesn't mean, and just because you wanted it to happen and you thought and you had the evil mind, but there was no act associated, not every crime can be considered concurrent at that time. There are some that, as long as there is one furtherance step, and we'll get to that later, furtherance step of one's act, one substantial step, then it can be linked and show concurrence. But in this case, mind and act happen together, right? Act and mind, concurrence, put together. So causation, 87, page 87. Where are we at here? Explaining causation, right? Causation. It's the requirement that the defendant is responsible for the harm in which results, whether factually or proximately. Factual causation being the requirement that the defendant's conduct was the cause in fact, with no doubt, of the harm, right? Cause in fact, factual causation. But for, you'll hear, but for one's action, this would not have happened. But for you drove intoxicated, you would not have been DUI crash. You would not have harmed you, yourself, property, or another. While proximately, when we talk about proximate cause, we're talking about proximation, talking about the location together in concept with the harm that put things together with the causation, the legal causation behind it. So factual cause, legal cause. So not only do you have the approximate cause, but you have the factual causes together. So now when we talk about factual and we talk about legal, we take factual from earlier, the but for what would the harm have occurred, and then we look at the legal cause, known as as the proximate cause. Putting together the primary act that sets the chain in motion, right? It is the proximate cause that focuses on whether it is fair to hold the defendant accountable for the harm, but for their action and their initiating action. Is it fair to hold the person responsible for their mind and their act, the concurrence of both, and the resultation? So with direct cause and intervening cause, we speak on things like the action of the defendant that is the causal, not casual, but causal agent that brings about the harm. Is there a direct cause of the defendant's action, right? But when we talk about intervening, we speak on any other events besides the actions of the defendant that resulted in the harm after the defendant acted. Again, but for their action. So you are intending to shoot a deer in the woods and legally doing so. And your bullet, which is aimed at the deer, ricochets off the tree and hits the hunter, whatever, just come up with some scenario here. Hits the hunter as it ricochets, and you've now caused harm to that person by hitting them with a bullet, right? Let's say shrapnel or whatever goes off and hits their leg. Your action is their direct and intervening cause. So the directed action might be that you were trying to shoot the deer. You weren't intending to shoot the person. However, your action was reckless enough and not and controlled enough environment that the cause, intervened. It still caused harm to another person. It's a proximate location. It's proximate cause together cause the harm. So again, direct causation, intervening causation, the whole idea of apparent safety comes in with that. Holding the defendant is not legal if the resulting harm, if the victim reaches a place of apparent safety, at which point an intervening cause of harm comes into play, right? So what do we have left? We're still talking about, harm, causation, mind, and act all together concurring. So when can someone, or if someone can use unknown, they did not know that something was a law, or they mistakenly interpreted the law. So when we talk about ignorance of the law and mistake of the law, you can have a mistake of fact, mistake of law. You can have a misunderstanding or a misinterpretation about a relevant fact, about a law, about something that happens, right? You can have again a misinterpretation of how a law is codified, or you can have possibly a concept of ignorance of law. I did not understand that was conduct that was criminal. I did not know that law applied to me in this certain circumstance. So everyone has a duty to inquire, in the words of Oliver Wendell Holmes. You have a duty to inquire about the legality of your actions. You are responsible solely for your action when it comes to intent, mens rea, actus reus. When it comes to putting all those together, you are still, at the end of the day, responsible for your actions and conduct in a specific society. So in terms of Western society, U.S. society, Virginia society, whatnot, you are the sole responsible party for yourself. Without going into the whole idea of someone else having legal responsibility for you, but as an adult, you're responsible for your action, right? So, is ignorance of the law a defense? If you did not know, is it? United States versus Monsini, a defendant resident in Italy mailed child pornography to an undercover officer of the United States. When he entered the United States, he was arrested for that law violation. In challenging his conviction, he said that the same conduct is not illegal in Italy, so he should be excused for his ignorance. However, the Ninth Circuit Court of Appeals said no, because you are ignorant of the laws of that land, of this land of the United States. You bear responsibility for your conduct. Makes sense, correct? Well, mistake of law. When we talk about mistake of law, we'll go through chapter 7 in a minute. Talk about mistake of law. We're talking about a person who thinks they're doing the right thing, or they are not clear that something was illegal or legal, or however you want to look at it. Someone who is not correct in their interpretation of the law. So when we go back to chapter 1 and chapter 2, and we're talking about clear and concise laws and the responsibility and the principles of lenity, if it's not a clear cut law, where does the responsibility fall on? Does it fall on the individual? Does it fall on the society to correct the law? Like I said, if you look at it, page 95 at the bottom, it says, consider the case of Hank, who went to the grocery store, selected 10 items from the shelves, visited a cashier who began scanning the items. Hank was talking on his cell phone, failed to notice the cashier missed an item. So, he wanted to buy 10, he paid for 9. He assumes that leaving the store that he paid for all those items. Security guard noticed that Hank was leaving without paying for that one item, so Hank was arrested and prosecuted for theft. It seems that he made an honest mistake. We can safely assume that he knew stealing was not acceptable, but he just failed to notice that the cashier missed something. That hypothetical scenario, mistake of law, mistake of fact, right? You have to look at these things. Ignorance of law. How do they apply? Do they apply with principles of legality and principles of lenity? Do they apply with ignorance? What do they apply with? So we'll take scenario-based discussions throughout this course and have you look at things and look at all the factors that have to go with the actual act. So that's chapter 3. Make sure you review the big terminology in this chapter. Actus reus, you will see that again. Mens rea, you will see that again. Strict liability, motive, modus operandi, harm, causation, concurrence. You're going to see all that stuff, again at some point. So some things to think about. You know, when you're talking about ignorance and mistake, when you're talking about the offense types and conduct and resulting harm, you know, what is, you know, the most important, characteristics of each crime when you put one in your head and you want to say shoplifting or you want to say DUI or you want to say assault and battery? What is the intent? Is the law written to help society or the individual or to deter the conduct? And we're going to get into deterrence and all that stuff as we go on.